I'm Scott Childress, one of the real estate closing attorneys at Grimm Rupert. Whether you're buying or selling a home in South Carolina, the closing or settlement process is where everything comes together. It's exciting, but it can feel overwhelming if you're not familiar with how it all works. In this video, we're going to walk you through what happens before, during, and after closing a residential real estate transaction in South Carolina, step by step. Contracting to purchase and sell. Real estate transactions in South Carolina start with a contract to sell a property that is agreed upon and ratified by the seller and the buyer, which is typically facilitated by their respective real estate agents. A real estate attorney can also assist in drafting the contract. Some of the key terms of a real estate contract are identifying the buyers and sellers, the purchase price, the address or description of the property, the amount of earnest money the buyer must put down, any contingencies such as the buyer obtaining financing or selling their current property, a due diligence timeframe that will allow the buyer to conduct inspections of the property condition, and a preferred closing date. Once a seller accepts the offer from the buyer, the contract is signed and has been given to the closing attorney. The buyer will deposit earnest money in escrow, which is typically held by the closing attorney during the closing process. Once the contract is received by the closing attorney, the office will request additional information from the buyers, sellers, and agents to get everything started. The sooner the closing attorney's team receives this, the sooner the closing process can begin. The closing attorney will work closely with each party's real estate agent in order to ensure open communication to keep all parties informed about the status of the transaction, work to schedule the closing, ensuring all necessary parties are present and prepared, resolve any issues that may arise, and ultimately reach the goal of a successful and legally sound real estate transaction. Another important step that the closing attorney will complete is a title search of the property. A title search is an examination of various public records to determine and verify the property's ownership and to discover any claims against the property. The title search is crucial because it could uncover issues that could hinder the transfer of the property from the seller to the buyer. A title search also ensures any existing liens, loans, or judgments are satisfied before closing is completed. If any issues are found during the title search, the closing attorney will take steps to cure the title and resolve the issue. Often the attorney will need assistance from the seller if there are issues to be resolved and will reach out to the seller for any needed records or to execute documents to clear up the title issues. During the title review process, the closing attorney will check to see if a survey has been completed on the property. A survey is important because it provides clear evidence of the property boundaries, helping to resolve encroachment disputes and ensure that future construction or development stays within legal limits. A survey can also prevent future legal conflicts by providing a clear record of the property lines and their relation to surrounding properties. If there is no survey completed on the property, or there is an outdated survey, the closing attorney will recommend the buyer complete a survey after purchase. Once the title search is complete and the title is clear, the closing attorney will issue a commitment to insure the property for the purchaser and their lender. During this time, the seller must also provide a property condition disclosure statement that outlines any known issues with the home. Meanwhile, during the due diligence period, the buyer schedules home inspections. This may include a general home inspection, a termite or wood infestation inspection, additional tests like for lead-based paint depending on the property and location. If inspections uncover issues, the buyer can request repairs or credits, renegotiate the price, or terminate the deal depending on the contract terms. Sellers can choose to agree, counter offer, or decline those requests. All negotiations must be in writing and completed within the deadlines outlined in the contract. Financing and mortgage process. If the buyer is financing the home, they will choose a home lender. Typically, this can be done even before the buyer chooses the property they would like to purchase. When the buyer has chosen a lender, they should send the contact information to the closing attorney as soon as possible. The buyer applies for a loan and provides personal financial documentation, such as bank and investment account statements, tax returns, and pay stub documentation for large deposits or gifts. When the buyer has chosen a lender, they should send the contact information to the closing attorney as soon as possible. The buyer applies for a loan and provides personal financial documentation, such as bank and investment account statements, tax returns and pay stubs, documentation for large deposits or gifts, records of debts, divorce settlements, or support obligations. Within 3 days of applying, the lender issues a loan estimate, formally called a good faith estimate, outlining estimated closing costs. A few tips: get pre-approved before making an offer. Don't make any other major financial changes like switching jobs or buying a car, or any other changes that may affect your credit during the process. Be ready to resend updated documents. Lenders often request recent versions to ensure your financial situation hasn't changed. The lender will also order an appraisal. If the appraisal comes in low and it's a contingency in the contract, the buyer may renegotiate or walk away depending on the contract terms. The closing attorney's office will work closely with the lender during the process to ensure that all closing costs are reflected in the final closing disclosure that will be sent to the purchaser. The document will also inform the purchaser how much they will need for cash to close, which will need to be wired to the closing attorney's office prior to the closing time. Regarding closing costs, the typical closing costs for buyers in South Carolina are lender fees, which can include loan origination fees, credit report fees, or appraisal fees, title search and title insurance fees, HOA fees such as prorated HOA dues and HOA capital contribution, homeowners insurance, prorated property taxes, and attorney's fees. Typical seller's fees include real estate agent commissions, transfer taxes, prorated property taxes, prorated HOA dues, and attorney's fees. The closing table. Closing day is the final step in the closing process where all parties meet to complete the transaction. Here's what typically happens. A final walkthrough of the property by the buyer will take place to ensure the home's condition hasn't changed. During the scheduled closing time, both parties will meet at the attorney's office to sign the final closing documents. They should remember to bring along a valid government photo ID, verify the date and time of the closing, as well as the address of the closing. Some closing attorneys have offices in multiple locations. It is also important to be on time to the closing appointment. Many closing attorneys will have multiple appointments throughout the day with many moving parts, and one delayed closing can delay the process. Closing attorneys will sit down with the parties to explain and facilitate the execution of the final closing documents. Buyers and sellers will have the opportunity to ask the attorney any questions they may have during the closing as well. For the seller, these documents will typically be a final closing disclosure, settlement statement, and the deed that will transfer the property to the buyer. Buyers will typically sign the final closing disclosure and settlement statement. If they are financing the purchase, they will sign a note, mortgage, and other documents that are required by their lender. The lender will often request a quick review of these documents before they allow the closing attorney to disperse funds. The buyer will receive a title insurance policy from the closing attorney that protects them against claims against the title of the property. Once all documents have been executed, and the closing attorney will record any legal documents like the deed and mortgage, and disperse funds to the seller and any third parties. At this time, the buyer will receive the keys and take possession of the property. Post-closing to-dos. Even after closing, there are a few things buyers will need to follow up on. If the property is your legal residence, you can apply for the legal residence property tax, which will allow for a 4% property tax rate. This process will be explained by the closing attorney at closing. If the property is a second home, investment, or other property subject to the 6% tax rate, you may apply for the ATI exemption, which will also be explained by the closing attorney. Hold on to your deed and title insurance documents. Remember, property taxes are usually prorated at closing, but the bill will still arrive later in the year. Closing on a home in South Carolina involves multiple steps, but with the right team, clear communication, and an understanding of what to expect, it doesn't have to be overwhelming. Remember, South Carolina is an attorney closing state, so your real estate attorney is your go-to resource throughout the process. From contracting and title work to lender coordination and legal compliance, Grimm Rupert is here to protect your interests and guide the transaction to a successful close. If you have any questions about this topic or any other real estate matters, please do not hesitate to reach out. We look forward to meeting you.